Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. SEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
We are here today with Kathy Robb, CEO of Robb Water Partners and nationally known water law practitioner, also a good friend and colleague for many years. After decades of private practice in water-related litigation and due diligence work across the country, Kathy is developing, through Robb Water Partners, a white paper on the Rio Grande River. This is for the International Boundary and Water Commission, IBWC. And she's focusing on developing a first of its kind blue bank, providing innovative financing to support sustainable projects, particularly projects addressing water scarcity. Kathy chaired the ABA's 31st Annual Water Law Conference and is an elected fellow in the American College of Environmental Lawyers, also known as ACOEL, and has many other recognitions and awards. I won't try to even begin on the list, but she does write and speak frequently, mainly on water-related law and policy. And in her latest article published in the Water Report, she titles it Groundwater and Surface Water, Are We Lurching Toward a New Reality in Federal Legal Considerations? And you know I'm going to ask you about the lurching because that's one of my favorite moves. So this is the subject of our podcast today. And Kathy, I will turn it over to you.
Oh, thanks, Roger. I'm delighted to be here today with you, Roger Sims, the CEO of Environmental Regulatory Services, LLC, and an expert water lawyer, practitioner, and a longtime colleague and friend. After decades of private practice in complex water-related disputes in Florida, Roger provides advice on water law and policy in Florida and nationally. Roger is an active member of the ABA, where he currently serves as co-chair of the program's subcommittee of the Water Resources Committee. Roger was also conference chair for the ABA Annual Water Law Conference, the 37th conference in 2019 in Denver. He's been recognized many times as a leading lawyer for his work in Florida and is a former chair of the Florida Bar Environmental and Land Use Law Section and president of the Florida Association for Water Quality Control. Great to see you, Roger.
And same here, Kathy. In your recent article, you focused on 4 Supreme Court cases. What interested you most about these cases in considering how the groundwater surface water connection is being treated in federal law? And why are we lurching?
Well, we all know that groundwater and surface water are connected and are best managed in concert. Historically, groundwater has not been considered as an integral part of surface water under the law. They're developed in artificial separation for a number of reasons. The court have historically looked at surface water. You can see it, touch it, feel it. In contrast, groundwater is not as easy to recognize, and its interrelation with surface water is even more intangible. When states and courts established laws and rules governing groundwater and surface water in the 19th and early 20th centuries, relatively little was understood about the movement and location of groundwater and its connection to surface water. And of course, science concerning groundwater is much more advanced these days, and analysis of aquifers, including modeling, is well developed. But the decisions were made case by case in the courts, of course, at the federal and the state and local levels. And so we're by definition piecemeal. This case-by-case development of water law continues today, built on case law developed over 100 years ago. Our key federal statute, in addition, the Clean Water Act, is 50 years old now. And finally, considerations of groundwater and surface water often require an analysis of the division of regulatory authority between the federal government and the states. All these factors impede us from developing a comprehensive water policy approach in the United States, hence the lurching. Every couple of years, Gallup polls Americans about their environmental concerns, and the last poll was taken in 2021. The majority responded that they were most worried a great deal was the definition, about water pollution, ranking it well ahead of, in this order, loss of tropical rainforests, climate change, air pollution, or the extinction of species. And that ranking order, with water first, has been consistent over the 2 decades that Gallup has taken the poll. It's clear that we value water and are interested in how best to protect it.
Kathy, how has the groundwater surface water connection played out in the cases you focused on in your article?
Well, I focused on these 3 U.S. Supreme Court cases that are relatively recent. The decisions in County of Maui v. Hawai'i Wildlife Fund, Mississippi v. Tennessee, and then the ongoing litigation before the court in Texas v. New Mexico and Colorado, because they reflect a relatively recent and slow but perceptible change to the traditional legal consideration of surface water and groundwater interaction at the federal level. It's long been known now that surface water and groundwater are hydraulically connected and inextricably linked. And modern conjunctive management of water reflects this, but still, the legal framework set up so long ago through common law and court decisions has largely remained the same. Congress generally deferred to the states to manage groundwater supply, with the federal government more directly managing quality. State regulation of groundwater, which in some states is quite extensive, is outside the scope of our discussion today, but it's also changing. Consideration of the connections between water quality and quantity and groundwater and surface water has heightened as we seek increasing water supplies generally, facing drought, population growth, and the resulting need for more water. Often the focus is on the potential to use surface water to recharge aquifers and the ability to recover stored groundwater. All these considerations are reflected in the County of Maui, Mississippi, and Texas cases.
What happened in the Maui case, which of course was decided in the context of a statute, the Clean Water Act, rather than an Article 3 dispute between states about water?
Well, in the Maui case, the Supreme Court applied the Clean Water Act and decided that a discharge through groundwater to navigable waters required a permit if it was the functional equivalent of a direct discharge from a point source. Now, at the Lahaina wastewater reclamation facility, the County of Maui injects 3 to 5 million gallons of recycled treated wastewater a day into 4 injection wells that are located a half-mile inland from the Pacific Ocean. The injection wells are these long pipes that carry effluent about 200 feet underground into shallow groundwater aquifer. The wastewater makes its way through the groundwater to the Pacific Ocean eventually. The facility was designed specifically this way and has been operating without a permit for years. Coral was seen to be dying in the area below the facility in the ocean. A tracer dye study was done and showed that 84 days after the dye was injected into 2 of the county's 4 wells, the dye emerged from the seafloor through points known as submarine springs. The idea that indirect discharges of pollutants to navigable waters through the groundwater are regulated under the Clean Water Act, which is sometimes known as the groundwater conduit theory, is not new. But groundwater has not generally been regulated under the Clean Water Act. The plaintiffs argued in the Maui case that the county's effluent injections were discharges from a point source, the wells, carried through the groundwater to navigable water, the Pacific Ocean, causing damage to coral reefs and violating the Clean Water Act. The county argued that the discharge from a point source must be made directly to navigable waters to come under the Clean Water Act. The Supreme Court held that the indirect discharge through groundwater to the Pacific was subject to regulation under the Clean Water Act and required a permit if it was the functional equivalent of a discharge.
So, how is functional equivalence to be determined?
Well, the Supreme Court laid out 7 factors that they thought may prove relevant, depending on the circumstances of a particular case, to determining whether the discharge satisfies the functional equivalent test. These include transit time, distance traveled, the nature of the material through which the pollutant is traveling, the extent to which the pollutant is diluted or chemically changed as it travels, the amount of pollutant entering the navigable waters relative to the amount of the pollutant that leaves the point source, the degree to which the pollutant at that point has maintained its specific identity. They noted that time and distance will be the most important factors in most cases, but not necessarily every case. And of course, in the Maui case, it was 84 days before the dye showed up. This functional equivalent determination requires a fact-specific inquiry, modeling, expert testimony to determine whether a particular indirect discharge requires an NPDES permit, all of which can be technically challenging and expensive. On remand from the court's decision, the district court applied the 7 factors from the Supreme Court, plus consideration of the volume of pollutants discharged, and required a permit of Maui, which the county applied for. Expensive modifications to the facility are anticipated to meet the permit requirements.
Kathy, what do you think are some of the factors that influence the outcome in Maui?
Well, the court noted that the structure of the statute indicates that as to groundwater pollution and non-point source pollution, Congress intended to leave substantial responsibility and autonomy to the states. The court also examined the legislative history of the Clean Water Act and concluded that the upshot is that Congress was fully aware of the need to address groundwater pollution, but it satisfied that need through a variety of state-specific controls. Congress left groundwater regulatory authority generally to the state. Its failure to include groundwater in the general EPA permitting provision is deliberate. Thus, the functional equivalent test defined by the court does not regulate groundwater categorically under the Clean Water Act, but it does reflect the justices' concerns stated in oral argument by several justices and in the opinion that the purpose of the statute is to protect the waters. And that concern carried the day. In oral argument, more than one justice expressed concern about leaving a loophole that would allow discharges into groundwater that avoid regulation and pollute the waters. One of the many other interesting aspects of the case is that the government flip-flopped in its position during the course of the litigation, reflecting in part changes in administration during the course of the Maui case. EPA had filed an amicus brief in Maui before the Ninth Circuit, supporting the view that Maui discharges required a permit if the discharges reached jurisdictional surface waters through groundwater with a direct hydrological connection to the surface water. But on April 15, 2019, just 10 days before the decision came out from the Supreme Court, EPA issued an interpretive statement reversing that position taken in the Ninth Circuit and stating that releases of pollutants to groundwater are categorically excluded from Clean Water Act jurisdiction because Congress explicitly left regulation of discharges to groundwater to the states and to EPA under other statutory authorities. And in its amicus brief to the Supreme Court, EPA argued that while the Clean Water Act permitting regime excludes groundwater, several other federal statutes address protection of groundwater, and many states regulate groundwater. There was no suggestion by the government that EPA's interpretive statement was entitled to deference by the Supreme Court under the Chevron doctrine, and the court's opinion in Maui 10 days later noted that the position taken in the interpretive statement by EPA indicated merely that EPA has changed its mind. In January of 2021, EPA issued interpretive guidance after the Maui decision, reiterating the functional equivalent factors and adding one more: system design and performance. And then in September of 2021, again reflecting change in part of administration, EPA withdrew that guidance, explaining in a short press release that the addition of that factor skewed the functional equivalent analysis in a way that could reduce the number of discharges requiring an NPDES permit, and therefore was inconsistent with the Maui decision. In the meantime, decisions are continuing to be made case by case. In the decision on remand in Maui, in addition, in a Seventh Circuit case called Prairie Rivers Network v. Daiichi Midwest Generation, the Seventh Circuit had stayed an appeal on a coal ash discharge case that had already been dismissed in the district court to consider the appeal after the Maui case was decided. And the Seventh Circuit ultimately concluded that the plaintiffs lacked standing, so they did not reach the application of the functional equivalent factors. Roger, you've thought a lot about the Maui case, and what's your take on it? Where do you think this will go in application?
I think, to say the least, Maui is going to make permitting of discharges to groundwater a whole lot more complicated. In some instances, it might not be that much different. For example, in Florida, NPDES permits and groundwater discharge permits are issued by the same agency, and the review could be coordinated. But there's going to have to be some sort of functional equivalence review, and that could get very involved. For example, in a karst or a limestone type subsurface architecture where you have a lot of permeability, you have channels running here and there and everywhere, and even features that could collapse due to changes in hydrology. Trying to pin all this down and show that, well, our groundwater discharge will not make it to the Gulf of Mexico or to the Atlantic Ocean or to any other waters of the United States in the region. Just proving that's not going to happen is going to be daunting, to say the least. I have one case where we had a demand to drill the entire property, which was over 10,000 acres. Drill every acre to see if there was a potential for a sinkhole to develop, and thus open a channel between surface water and groundwater, and allowing pollution of the groundwater. Well, now we may have the same sort of thing to try to prove that there won't be any discharge into these subsurface channels. And that's just, no matter how many drilling centers you have, it's going to be hard to say it absolutely won't happen. So waters of the United States, really has become a different sort of a thing. Waters of the United States are WOTUS. were extended in Maui to include groundwater, as we've been reviewing. But EPA has also been busy on the WOTUS process. Kathy, what thoughts do you have on that issue?
Well, continuing in the 20 years long debate, some might say 50 years long debate about the jurisdiction of the Clean Water Act, EPA finalized a new definition of WOTUS in 2015 during the Maui case. That rule, called the Clean Water Rule, was challenged in litigation of epic proportions and the subject of 1,000 seminars and conferences. At one point during the litigation of the rules, as a result of various court stays and rulings, half the United States was under a different definition of WOTUS than the other half, which made work very interesting for adjacent states with water flows across borders. Proponents found the Clean Water Rule, the 2015 rule, more protective of navigable waters. Opponents argued it would drastically expand navigable waters at great additional cost and resources to the states implementing the Clean Water Act permitting programs. The states were about evenly split in their views. And just as an example, Kansas estimated that the additional jurisdiction under the 2015 rule would go from an estimated 32,000 miles of stream to 134,000 miles of streams in its state. The 2015 Clean Water Rule was eventually replaced by the 2019 rule, the Navigable Waters Protection Rule, which excluded groundwater, including groundwater drained through subsurface drainage systems. So arguably, it would have reversed the decision in Maui from the jurisdictional waters. And it had 11 other explicit exclusions. That rule, also the subject of massive litigation, has now been withdrawn. EPA and the Army Corps of Engineers announced last year in June that they intended to revise the definition of waters of the United States. And in the meantime, EPA is implementing the pre-2015 regulatory definition and practice of waters of the United States. They also announced on December 7th, 2021, a proposed rule to that effect, that they're going to, for the meantime, implement the pre-2015 regulatory definition. The pre-2015 regulatory definition dates from 1986, which is essentially the same regulatory scheme as the 1977 regulations. So we are in 1977 now in terms of implementation. And in May, just last month, EPA scheduled 10 roundtables among diverse stakeholders to talk about the anticipated second rule that will define waters of the United States going forward. EPA and the Corps are clearly still working on that.
Okay, turning to equitable apportionment cases, how does the court consider these, and what does the factual dispute in the Mississippi versus Tennessee case involve?
Well, in Mississippi v. Tennessee, Mississippi alleged that Tennessee was allowing Memphis to take Mississippi groundwater by pumping it from a shared aquifer. The Supreme Court decided that equitable apportionment, a well-developed doctrine applied to surface water disputes between states, will now be applied to groundwater disputes. The Supreme Court issued its unanimous opinion in Mississippi v. Tennessee, holding that water in an underground aquifer that flows across state lines is subject to equitable apportionment between the states in similar fashion to interstate streams and rivers, which of course is surface waters. The case was decided in November of 2021 and just 7 weeks after oral argument. First, about equitable apportionment. Under the Constitution, the Supreme Court has original jurisdiction over equitable apportionment for interstate waters. The process is expensive and time-consuming. It's fact intensive, often requires multiple parties. It's driven by hydrological models and expert testimony given over a period of years before a special master who is appointed by the court. All of this is funded by the involved parties. The court previously has applied the doctrine of equitable apportionment to the interstate rivers and streams, interstate river basins, and even to cases where groundwater pumping is affecting the flow of interstate surface water or for the benefit of anadromous fish. Anadromous fish are born in freshwater, live most of their lives in saltwater, but return to freshwater to spawn. They're like salmon, sturgeon. The burden is to establish apportionment is very heavy. The state seeking apportionment must establish by clear and convincing evidence to the court that the use objected to is causing real or substantial injury or damage to the state's substantial interests, and must persuade the court that the nature and magnitude of the injuries claimed are sufficient to justify the impacts from the reductions the interstate seeks against the injuring state. As with many water cases between states, there's a long history here between Mississippi and Tennessee. In 2005, Mississippi originally had filed a claim in federal district court against Memphis and Memphis Light, Gas, and Water, but not the state of Tennessee. Rather than bring an equitable apportionment claim in the Supreme Court, Mississippi argued instead that it owned outright the groundwater being pumped in Memphis and sought an injunction and compensation for the water. That claim was ultimately dismissed by the Fifth Circuit, which noted, interestingly, in dismissing the claim, that it saw no analytical difference between rivers on the surface and water under the ground, rejecting Mississippi's assertion that water below the ground should be treated differently. In the case brought before the Supreme Court, Mississippi filed a motion in 2014 for leave to file a complaint, again naming Memphis and Memphis Light, Gas, and Water, and adding Tennessee as a party. Mississippi relied on its claim of absolute ownership of groundwater as a matter of right as a state when it first entered into the Union in 1817, even after the water has left Mississippi borders, and sought damages and injunctive relief, specifically disclaiming reliance on the doctrine of equitable apportionment. So the aquifer that's under dispute here is the Middle Claiborne Aquifer, and it underlies 8 states. The city of Memphis has been pumping from that aquifer for over 130 years and currently pumps an estimated 120 million gallons a day from the aquifer, all from wells located in Tennessee. The cone of depression created by this pumping moves groundwater from Mississippi to Tennessee at slightly greater rate than in pre-development days, but the depth to water in Northwest Mississippi has not lowered more than a few inches, and the water use does not prevent or limit access to groundwater in Mississippi. Some aquifer water naturally flows from Mississippi to Tennessee. There aren't any compacts or decree apportionments between Mississippi and Tennessee on surface water or groundwater. During oral argument, the justices expressed concern about applying the equitable apportionment doctrine to groundwater, fearing that many original jurisdiction cases about interstate aquifers would result, overrunning the court. But concerns about states having an equal right to reasonable use of shared water resources through a fair allocation clearly won the day over potential additional cases being brought under the court's original jurisdiction. In the unanimous opinion, the court rejected Mississippi's ownership argument and held that the doctrine of equitable apportionment applied to the Middle Claiborne Aquifer and that Tennessee had established that. In terms of what might be the potential impacts of Mississippi v. Tennessee, first, the court now has held for the first time that equitable apportionment applies to interstate aquifers. When and how it applies remains to be seen. The harm, as I said, is a difficult one to establish. We're likely to see more of these kinds of claims, though, given the pressures on water resources. There are 68 regionally extensive aquifers identified in the United States, with many stretching across state boundaries. And the Supreme Court's holding may encourage states, though, to reach agreement on transparent boundary groundwater resources through a compact, obviating the need for an equitable apportionment litigation. That bodes well for conjunctive management, harmoniously managing surface water and groundwater, with the focus on equitable apportionment for both transboundary surface water and transboundary groundwater. Perhaps innovative trade-offs could be negotiated on each between parties dealing with both issues.
Well, finally, what have Texas and New Mexico been fighting over all these years?
Well, they've been fighting over water for a long time. In this latest bout, which began in 2014, attorneys representing Texas filed a lawsuit in the Supreme Court against New Mexico and Colorado, alleging that New Mexico violated the Rio Grande River Compact and took more than its fair share of water in the river. Unlike Mississippi v. Tennessee, the case involves a compact, and the complaint was filed in the first instance in the Supreme Court under original jurisdiction. But like the Mississippi case, the relationship between groundwater and surface water is critical to the claims. The case is ongoing and currently is in settlement discussions. Texas alleges that New Mexico farmers are pumping groundwater from wells hydrologically connected to the Rio Grande south of Elephant Butte, and that New Mexico is complicit in this activity. Colorado is only a named defendant here because it's a signatory to the compact. In the complaint, Texas states that the pumping reduces the apportionment of water it is entitled to by tens of thousands of acre feet each year, and asks the Supreme Court to order New Mexico to pay about $1 billion for water owed over decades for the water it did not receive in Texas. If New Mexico loses, that could curtail groundwater pumping in New Mexico and jeopardize certain New Mexican water rights. The Rio Grande originates in Colorado, flows south into New Mexico, and flows into Texas near El Paso. The 82-year-old Rio Grande Compact, entered into by the three states and ratified by Congress in 1939, apportions the water of the Rio Grande Basin among the three states. Among other things, the compact provides that Colorado must deliver a specific quantity of water to the New Mexico state line, and then New Mexico must deliver a specific quantity of water to the Elephant Butte Reservoir. That's a Federal Bureau of Reclamation project built as part of the Rio Grande project that distributes water to New Mexico and Texas. The water stored at Elephant Butte is used for irrigation districts in New Mexico and Texas, the allocation for Texas, and to provide Mexico its share of Rio Grande water. Elephant Butte, though, is in New Mexico and is over 100 miles from the Texas state line. It was chosen the delivery point to support downstream contracts simultaneously entered into with the 1939 compact and promising Texas a certain amount of water from the reservoir annually. Elephant Butte was and still is the only project reservoir storage in the area, and groundwater pumping in New Mexico between Elephant Butte and the Texas border is therefore occurring after the delivery point, but before the Texas border. So the surface water is not reaching Texas New Mexico argues it's meeting its obligations because it is delivering the water to Elephant Butte. The United States moved to intervene in this lawsuit in 2014, which is somewhat unusual. The US sided with Texas, claiming that New Mexico's groundwater activity depleted the water, both threatening the United States' ability to fulfill treaty obligations to Mexico and harming the agency's ability to deliver water to the irrigation districts. The then special master finalized his first report in 2016, recommending that the court reject New Mexico's motion for dismissal, allow the federal government to join the lawsuit, and reject irrigation districts joining as members to the suit. You can see how these cases take an enormous amount of time. In March of 2018, the US Supreme Court issued a unanimous opinion limited to the United States motion to join the lawsuit and granted their request. The court's opinion was written by Justice Gorsuch and began, Will Rogers reportedly called the Rio Grande the only river I ever saw that needed irrigation. The opinion was solely limited to the question of intervention by the Bureau, and all other exceptions to the 2016 Special Master's report were summarily overruled.
And what is the status of that litigation?
Well, after the decision, New Mexico filed counterclaims in 2018 against Texas and the Bureau, and they alleged that the federal government had failed to allocate water fairly and alleged a number of accounting issues about the Texas and Mexico water allocations, all related to the compact. New Mexico alleged Texas groundwater pumping allowed Texas to take surface water greater than its share and violated the compact as well. New Mexico also said Texas' alleged activity requires greater releases from the Rio Grande to offset their groundwater use, causing indirect harm, and they want damages against Texas. The spring trial that was set was postponed to the fall of 2022 this year to accommodate confidential settlement talks among the parties, and the hope is that they will reach settlement.
How is this case related to Maui and Mississippi versus Tennessee?
Well, in Texas v. New Mexico, we once again have claims between states that water rights are being affected due to groundwater pumping, and the court being called upon to consider the connection of surface water and groundwater in applying the applicable law, similar to the Mississippi case. In the resolution of the Mississippi case and in the decisions issued so far in the Texas case, the court has acknowledged the connection between groundwater and surface water in its legal considerations. And in the Maui case, has read a statute to include the role groundwater can play in surface water contamination. Each case has expanded, therefore, how we think about the interplay of groundwater and surface water under the law. Roger, all three of these cases rely of necessity heavily on modeling. I know you've dealt with modeling in much of your work. It was interesting that the special master included in Texas v. New Mexico the modeling records in an appended disc to the special master's opinion. What's been your experience, Roger, in modeling these water cases?
Well, modeling, first of all, is data intensive. You got to have a lot of information to come up with a valid result. Getting good information takes time. First of all, you collect what's already been done, but then very often you have to go out and gather more. So that's kind of a stage one in the whole process. But then you have to decide methodology. What program are you going to use? There's various programs. One that's been used for decades is the Corps of Engineers ModFlow program. There's a Scandinavian developed model of Mike Shee. And there are models that are developed to address specific regional issues. including, for example, areas of heavy competition for water and arguments about who's doing what to whom, similar to what Kathy, what you just described in Texas v. New Mexico. Once you have the model set up, you also have to call out the input parameters, and they can include things like transmissivity, storage, and leakage. To calculate transmissivity, you may have to run a pumping test, or to calculate any of these. Pumping tests are expensive and time-consuming, and often the agencies get very involved in telling you how to do it. So that's a big deal. And when you're doing any of these groundwater studies, calibration of the modeling effort to reality is always a big concern. So yes, modeling is expensive and it's time-consuming. It has, however, been shown to be a very valuable tool in evaluating what impacts occur from pumping at point X when you're considering, for example, surface water at point Y, or the Texas, New Mexico case. It's going to, I think, become even more complicated now that we have a federal layer that's been placed over these issues. So I would say stay tuned and let the good times roll. So what's the takeaway from these cases, Kathy? How are they altering our approach to groundwater, surface water in federal law?
Well, I agree with you that at a minimum, we're going to be seeing a lot more modeling as people consider groundwater and surface water interaction. But the three cases also illustrate the interest by plaintiffs to pursue issues of groundwater and surface water interaction, and the court to consider them, applying existing law that was developed without the benefit of current science to these new and complex claims. To be sure, we are going to see more of these kinds of claims given the struggle to meet our water demands. And on a positive note, at least I hope it will be positive, the resolutions reached may spur innovation that moves the needle on complex water supply and supply issues that we face.
Kathy, many thanks for an absolutely wonderful discussion here today of the cases that you've included in your article. And we look forward to working with you in the future. And hopefully those who listen to this podcast will get the benefit that's been put into making it. And we thank you all very much for your time and attention.
Roger, it's been so much fun being here with you, and thank you, and to the ABA.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at www.americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.